So please, if they are in, I invite Sokol Sadushi, Albania. Good morning. Welcome. Alexander Bröstl, Slovakia. Remzije Istrefi-Peci, Kosovo. Good morning. Cristina Hermida de Llano, Spain. Valentina Colcelli, Italy. Bronfman, Chile. Ruth Bogatyrow, Kraft, United States. Good morning. Ricardo Rios Ferrer, Mexico. And finally, Cristina Titirishka, Romania. Cristina is in? Okay. Just a very short remark. Thank you for being here. Muchas gracias por estar acá. Estamos un poco retrasados por razones de acceso al edificio. We are a little bit late for reasons related to the access to the building, but in any case, unfortunately, we have each a very short time, because you know that in this same room, a further panel is going to start at 10:30. We can have a flexibility of maximum 5-10 minutes, but I'm really very sorry with you. You should try to speak each no more than 7 minutes. I know that it is a very short time, but just a second very short remark. As a matter of fact, I am coordinating this panel, but I want to remark that I am only a substitute. A very, let's say, simple and unworthy substitute of a great scholar in constitutional law. And that scholar was Rainer Arnold. Professor Rainer Arnold was a great constitutional lawyer, an extraordinary man, extraordinary husband, extraordinary father. We have here the honor and the privilege to have his wife and his daughter, Barbara and Antonia. He was a great friend that we lost suddenly, only a few months ago. I am sure, definitely sure, that he is now here with us. And as a matter of fact, he is coordinating our works this morning, not me. I am not worthy about it, for it. He is coordinating our works. So it is in the name of Rainer that we are going to work in this panel. The topic, science, technology, and law, is a very complex and difficult topic about which we already debated 1 year ago in Bologna. And the results of the proceedings of that seminar were already published with the contribution of some of you here, Professor Bröstl, for instance, Professor Vorpsi from Albania, and so on. Professor Granat from Poland. Thank you, Miroslav, for being here. And it is a topic that is related to fundamental rights, constitutional justice, also governmental organization, and so on. So I'm sure that each of you will be able to contribute in a very important way to facilitate us knowledges on this topic. Unfortunately, I think that we won't have any time for debating, but if you want, we could create a chat by mail to exchange opinions, remarks, and so on. So let's go on. The first contribution, the first panel, la primera intervención is of colleague Sokol Sadushi from Albania, President of the Supreme Court of Albania. Thank you very much.
Thank you. Thank you, Professor Mezzetti. Honorable chairs, distinguished colleagues, ladies and gentlemen. On behalf of the Supreme Court of the Republic of Albania, I extend our sincere gratitude to the World Law Congress for the distinct honor of selecting Albania as the host country for its 2027 edition. This decision represents not only recognition of our country's comprehensive reforms, our unwavering commitment to strengthening the rule of law, but also a valuable opportunity to welcome the world's foremost legal minds to the heart of Europe. We are proud to open our doors to this esteemed international forum. Albania is committed to fostering an environment to open dialogue, mutual learning, and the advancement of justice. We look forward to welcome you to our country in 2027 and sharing with you our legal journey, our cultural heritage, and our deep-rooted tradition of hospitality. It is both a privilege and a responsibility to speak before you today at the World Law Congress 2027 here in the Dominican Republic. The themes of this panel, the intersection of rule of law, science, and technology, is timely, essential, and profoundly relevant to our ongoing transformation. Reconstruction, the foundation of the rule of law. The rule of law is the foundation up which Albania's democratic institutions stand. Over recent years, Albania has undertaken one of the most comprehensive judicial reform initiative in its modern history, an initiative focused on judicial independence, accountability, and transparency. Anchored in our constitutional values are guided by the aspiration of the European integration. We have restructured core institutions, implemented a rigorous vetting process for judges and prosecutors, and elevated ethical standards across the board. While these changes have been complex and at times difficult, they have been both necessary and transformative. Yet reforming the institution is only part of the challenge. We must also ensure that these institutions deliver justice efficiently, fairly, and in a manner aligned with expectation of a rapidly evolving society. The public trust in the rule of law requires not only integrity, but also accessibility, efficiency, and modernity. This expectation brings us to the next frontier, technology. This is the critical link between the rule of law and scientific progress. In Albania, the digital transformation of the judiciary is not optional. It is a national necessity. It is a key pillar of our justice reform strategy and the foundation element of our alignment with European standards of good governance. Post-reform Supreme Court of Albania in 2020 confronted a backlog of more than 36,000 unresolved cases, a situation exacerbated by delays in judicial appointment. Addressing this crisis requires innovation, resilience, and strategic pivot toward digitization. Until just a few years ago, petitioners had to wait outside the courtroom to be informed of their case status and receive judgment directly from court officers. Since 2016, the implementation of email notification available for registered parties in cassation appeals, along with more transparent publication of court documents, has enhanced public trust in our judiciary. Together with other leading judiciary institutions, we are now developing a unifying case management system that will integrate levels of the judiciary, enabling faster and more transparent processing of cases across jurisdiction. Although artificial intelligence is not currently used in decision-making, we have embraced technology as means as increasing transparency. As of April 2025, the Supreme Court launched as open data platform on its website, offering organized and accessibility insight into judicial activity from decision to the institution update. This approach empowers both citizens and legal professionals with the information they need to understand and evaluate judicial performance. Digital transparency is not merely administrative. It is a form of democratic accountability. It affirms the right of the public not only to observe justice, but to comprehend and engage with it. Altogether, with the positive use of the technology in terms of transparency, the Supreme Court of Albania was confronted with two high-impact cases regarding the use of electronic evidence in criminal proceedings, EncroChat, and the protection of journalist source when dealing with a mass data leak investigation. In the first case, the Supreme Court upheld the lower court's decision to order a personal security measure on a group of suspects based on the electronic communication via EncroChat provided as evidence by the Office of the Prosecutor in collaborating with foreign judiciary and law enforcement partners. Later on, the Constitutional Court issued a leading decision which upheld the finding of the Supreme Court and validated the use of this evidence in criminal proceedings when corroborated by other additional evidence. In the second case, the Supreme Court had to decide on the seizure of the confidential information stored in personal digital devices of a group of journalists who were investigating a major leak of personal data. The court elaborated many principles in its unifying decision. However, what was difficult to distinguish in this case was whether the said evidence on the matter being investigated could be individualized. In its unifying decision, the criminal chamber of the Supreme Court considered that the principle of necessity, suitability, and proportionality must guide the court decision-making, both in ensuring on order for the seizure of the computer data and in determining the specific modalities by which such seizure is to be carried out. We have also embraced more dynamic and inclusive channel of communication. The Supreme Court not regularly issue a digital newsletter and actively engage the public through platforms such as LinkedIn and Facebook. We have developed dedicated only sections such as Judix, which offer in-depth resource or legal research and case law. This communication effort have transformed the law the judiciary related to the public. Once perceived as a remote institution, the judiciary is now seen as responsive, open, and engaged. Through real-time update, decision summaries, public education, and interactive feedback, we are nurturing a more informed and confident public. Challenge and ethical cooperation. Not all citizens have equal access to digital tools. True access to justice must include access to technology. For example, the e-Albanian platform, though widely used for administrative service, has not yet been extended to judicial function. We aim to introduce legal reform that would allow the judiciary to benefit from this platform's database and process party-relevant data in real time. As we digitize court system, we must safeguard personal data, preserve the integrity of case files, and uphold due process protection. Technology may support decision-making, but can never replace the human judgment and independence that are core to justice. Judges, lawyers, and staff must be equipped with new skills. While the legal profession can be cautious in adopting change, we must involve to meet modern demand. As we look to the future, one truth stands clear. Court digitization cannot happen in isolation. It requires cooperation among the judiciary, IT experts, civil society, academia, and international institutions. In Albania, we envision a judiciary that embraces change, leads with integrity, and involved with the needs of society, and anchored in the rule of law, enriched by science, and empowered by technology. Through international forums like this Congress, we have the opportunity to exchange best practice, shape joint standards, and ensure that justice system worldwide remain inclusive, adaptable, and resilient in the face of the technological change. In conclusion, let me reaffirm a belief we hold deeply. The rule of law is not static. It is a living principle, one that must grow alongside society, science, and technology. The Albanian judiciary, shaped by its unique historical context, is committed to this evaluation. Our mission is to ensure that justice is delivered wisely, transparently, and in step with the modern world. Thank you for the opportunity to share Albanian experience and vision. I look forward to hearing your insight and continuing this vital global dialogue. Faleminderit. Thank you.
Thank you, Mr. President. The second intervention is by Professor Alexander Bröstl, Slovak Republic. Professor Bröstl was a member of the Constitutional Tribunal of the Slovak Republic from 2000 to 2007. Please, Professor Bröstl.
Thank you very much. Buenos días. Señores y señores, todo el mundo. I have to thank first for this kind invitation, which goes to Professor Arnold, and I'm very glad to see Barbara here. And as Luca mentioned, Professor Arnold is here with us. It goes also to the title of my paper, because we consulted it, and the title is Rule of Law, Technology and Law Course, a view under the veil of the philosophical backgrounds. So in a few minutes, I will try it. Let's start from imagination, because it will be on imagination. Remember the words of our well-known song, Imagine. Imagine all the people living lives in peace through law, in peace through the rule of law, as we say. Starting collecting information for my presentation, and it will look like I used artificial intelligence, you will see, but it's not true. Just starting by George Bernard Shaw as emphasizing two main ideas. drove attention to Plato, who long ago pointed out the importance of being governed by men with sufficient sense of responsibility and comprehension of public duties to be very reluctant to undertake the work of governing. By the way, we have discussed it. Gobierno and government has very much to do with cybernetics, because the original Greek, ancient Greek word, which Plato, with using Socrates, discussed was kybernai, and this is government, clearly derived in Spanish and in English. So, and Socrates in Plato was speaking about the skills of governing, this is true, and using this word kybernai, ruling the state, let's say politeia, in general, the skill in general, overall, the forms of government. Then in his brave new world, Aldous Huxley pointed out that the potential of dictators and would-be dictators is to exploit emerging technologies to produce propaganda that bypass the rational side of man and causes him actually love his slavery. This panem et circenses now, because give the people games and bread and that's it. And you can hide your power intentions and the rule of power, in fact, not the rule of law. I can close this, let's say, second minute about the rule of law and the rule of power and continue by Huxley. And this is, I think, very important and very actual. Dictators can always consolidate, and you can use the word leaders, let's say demagogues in this way, it will fit, can always consolidate their tyranny by an appeal, or dictate by an appeal to patriotism or nationalism. Anyway, the government uses advanced technology and psychological manipulation to maintain stability and happiness among the population. The power elite controls many millions more by lending them money to buy its products, and through its ownership of the media, of mass communication, influences the thought and the actions of virtually everybody. Generalized intelligence and mental alertness are the most powerful enemies of dictatorship, and at the same time the basic condition of effective democracy. So that's why this is a coincidence with the rule of law. What I have mentioned before, this is almost a quotation of Aldous Huxley, New Brave World. But I can confess that I didn't use artificial intelligence for this, because if you start nowadays, let's say a paper, so you are collecting information, you are thinking about it, how to structure it, about the sources. But because I read Aldous Huxley before, so I was a bit quicker than artificial intelligence. Because, by the way, you can ask about, let's say, this manipulation, and you will get the same thing, the piece of Aldous Huxley's work, but I am proud that I was quicker in this situation. But it is because reading books. Nowadays it is click into your computer and ask for information, and you will get it after some time, maybe. It depends on putting questions, of course, of questioning. So the second remark, I had included in my paper some considerations of intelligence. What do we understand about intelligence? Because it's not so one-sided or absolute. Artificial intelligence, because the science of, let's say, intelligence is creativity. All people, let's say, in power, also with AI, Bill Gates, Elon Musk, Zuckerberg, and so on, they are speaking about this is good for the people because developing creativity and be more efficient and quicker. And you will save time for thinking maybe and evaluating to help creativity. But it is a puzzle, a question, and this was the initial question we asked in Bologna, and an old question, whether machines can think. This was the initial. Now we have machine reading, we have machine teaching, machine learning, so you know, and machines are very much efficienter than human brains and human thinking. But I would like to underline 3 points of definitions of intelligence, and this is understanding, creativity, and critical thinking. And this is still a puzzle, because these are mathematics models used, logics on IA. But it is still maybe something similar but different with the human brain. And this is the target of neurology and other sciences, to link this research with artificial intelligence. So this last, as I know about the Harvard discussion and other discussions, are also brain reading and try to read the human brain in a way through neuroscience and this other developed tools. And this would be a next step, how to can read ideas in the brain. It can be a mathematics, model mathematics, but it is possible in a way, or the result can be discussed. And then it is another step, let's say, for the future, and this step is dangerous. This is manipulation, and because you can control others, also others' mind, your own mind, by like screening by a chip. This is the future, by a chip, and maybe this chip can contact and read other people's brain and the mind. This is a serious program. Yes, yes. 2 minutes, but I will close soon. Anyhow, if I'm speaking about creativity, so also abuse of intelligence and AI is a type of creativity. It is another type of creativity we don't like, but it is creative. Then maybe to emphasize dependence on and also trust in AI can bring the loss of creativity and the ability of critical thinking. This can be the result. Use too much AI and to think that it is an absolute product, that it is truth, absolute truth, like, and you can use it for also supporting decision makings. Anyhow, you can use it. Last part, to use AI in the field of legal science, and I have been speaking in Bologna about AI in lawmaking and law application. So, and I will skip this lawmaking a bit, because of course AI can be very quick and very effective in collecting, let's say, materials for immediate drafts and many varieties which should be then controlled by human intelligence. Law application, and this is more tricky, is use, as we know, AI in courts, in decision making, of course, as in the preparatory stage, but about the final product, when you ask some questions in AI, and then to evaluate and to use it. What is the proper way? It's on discussion. I'm not going to speak about manipulation. This is human. From the input and output, then can be manipulation and this rule of power behind. And I'm not going to speak about hallucination, because AI can hallucinate. We have made some research, and I can quote it. We have been speaking with AI, with chat boxes, various one, and we have some results got on questioning and evaluating AI in this respect. I can speak in the discussion more about, because we have done some serious research also in cooperation with Australia, the University of Sydney, and some home or Austrian or German experience. So far also Italian, because I have some doctoral students from Italy. Thank you very much. Muchas gracias, and I am prepared for the discussion. Thank you.
Thank you very much, Professor Bröstl. Muchas gracias, Professor Bröstl, por su ponencia. Now the floor is to Remzije Istrefi-Peci from Kosovo, member of the Constitutional Tribunal of the Republic of Kosovo. Ahora la intervención de Remzije Istrefi-Peci, Kosovo, magistrado del Tribunal Constitucional de Kosovo.
Thank you, Professor. I really would like to use my valuable minutes, and avail this opportunity also to extend the gratitude of the work of our dear Professor Reiner. I think this audience, and in particular the family of Professor Reiner and this respected panel, deserves also to learn about his work in Republic of Kosovo. I come from the Constitutional Court of Kosovo, which is the newest one in Europe for sure, but also in the world. And Professor Reiner was with us all the time. My court was established in 2008 after the declaration of independence of Kosovo. The first cases have been heard in 2009. Professor Reiner was all the time with us. He built our capacities, he invested in our court, and he made a history on my country. So thank you very much to the family, to the collaborators, Professor Luca, and all panelists. Now, it is a great pleasure, actually, for me to be part of this distinguished panel. It is a great pleasure to listen to the previous speakers, and I learned a lot from their discussions, and allow me to share my thoughts within the overarching topic of our panel, a rule of law, science, and technology, and I would like to concentrate my presentation on the potential future risks to gender equality and information technology. In that sense, considering the fact that we have a very limited time frame, I would like to concentrate my presentation in the potential future risks to gender equality. Then I will talk about the interaction between digital spaces and gender-based violence, trying to discuss some of the challenges and measures that have been taken in order to provide for the right balance between the benefits and harms that do derive from the age of technology. These challenges, I will try to put them in the Western Balkan countries because I come from that part of the world, and the main fact is that most of the Western Balkan countries are not part of the international organization system. We are not a part of European Union, and we are not under the guarantees that these institutions provide for. So in this context, I will try to bring the discussion at this level. So I will go quickly to some of the dangers that I think that relate to the gender-based violence and information technology. At first, potential economic and political backlash. Since economic crisis may lead to increased domestic violence as a result of financial dependence rise, while political instability and backlash against gender rights movements could weaken legal protections and access to support services. Second, I think that healthcare and reproductive rights do challenge, may lead the restrictions on sexual and reproductive health rights, potentially resulting to increased risks of forced pregnancies, unsafe abortions, and reproductive coercion. Third, conflict and climate-related risks. Also, they may lead to displacement, they may increase the gender-based violence due to the weakened law enforcement and social instability. And fourth, increased online and tech-facilitated gender-based violence, including gaps and ambiguity in cybersecurity laws and weak enforcement mechanisms that may allow perpetrators to operate with impunity. In terms of increased online and tech-facilitated gender-based violence, I want to share a fact with you. And it is that according to UN Women, 73% of women globally have experienced or been exposed to some form of online violence. Taking into account the rapid development of technology, but also the benefit it entails, awareness of the risks and initiatives and measures undertaken to counterbalance the harm have not been immediate and are relatively recent, actually. The Council of Europe has in fact been among the first to react to the risks of this phenomenon. Initially through the Budapest, namely Cybercrime Convention in 2001, which is quite recently, and subsequently the Istanbul Convention 2014. Also, I would like to emphasize the Gravios Recommendation number 1, which focuses on the digital dimension of violence against women. Also, the European Court of Human Rights has already addressed the intersection of online harm and gender-based violence in several cases, including in respect of the discrimination dimension, interpreting provisions of the European Convention to tackle digital manifestation of abuse. The standards set in the cases that the European Court has dealt with mention that there is a specific case in this principle. I refer to the case Volodina versus Russia, 2019, Borotruga versus Romania, 2020, and recently, X versus Cyprus, 2025. Also, I want to mention the EU action related to the adoption of the first Digital Service Act and its full implementation, contributing to the strengthening of the protections for women against cyberstalking, online harassment, non-consensual image sharing, and other forms of digital violence towards the gender-based and women in general. So all these aspects actually, if I go back and put them in the context of challenges addressing the online dimension of gender-based violence in the Western Balkans context, the common denominator of features that characterize this region must be taken into account. The features of the Western Balkan region amplify the risks of online harm to gender equality and gender-based violence. In order to contextualize this statement, I would like to place a reminder on the fact that none of these countries are a member of European Union. Not all the members are the members of Council of Europe, so they struggle with, and many of them struggle with democratic and economic development and consolidation. A recent report published by Aspen Institute addresses the issue pertaining to digitalization and democratization in the Western Balkans, and it emphasizes the fact that the region grapples with serious regulatory challenges, making it difficult to combat also the illegal online crimes. While the countries of the region generally have advanced constitutional and legal frameworks, including application of Istanbul Convention, as to the Grevio notes, this is primarily a result of weaker judiciaries, including in terms of length of proceedings and insufficient strong systems that enable the cooperation among states. Generally, the research so far shows that in the Western Balkans, the following are the most challenging issues: lack of proper cooperation among state and non-state actors in preventing and prosecuting crimes that relate to gender-based violence, including femicide; lack of proper classification of crimes motivated by gender, also as a result of weak analysis of the motives pertaining to gender-based motives; a disbalance between the aggravating and mitigating factors like family and issues that relate to economic development. So generally, the Western Balkan research published so far reports on the fact that there are two various aspects on how online harms affect gender-based violence. At first, the digital space as a platform for silencing women and feminist movements, and also the digital space where crimes are not perceived to be serious enough, and this is reflected through the judicial response on the online harm. We have examples where the online platforms have been used to silence women and feminist movement. The latest one, maybe to be mentioned, is the one that used in Serbia, for example, for mobilizing against Europride 2022 in Belgrade through an online platform. While related to the digital space where crimes are not perceived to be serious enough, for instance, my country, Kosovo, North Macedonia, but to a certain extent, more or less Bosnia and Herzegovina reflect the same patterns. The cases in the court system have been tried very slowly and with very low sentences. So in this sense, I would try to provide some recommendations. At first, there is a need to strengthen legal frameworks and enforcement. While the constitutional frameworks and gender equality laws are generally sound in the Western Balkans, they need to align also with EU Digital Service Act and the requirements deriving from the case law of the European Court for Human Rights. Second, to enhance data collection and monitoring. I mentioned this because we need data in order to know what exactly is going on, because most of the cases, according to the research, they go unnoticed because there is a lack of reporting. Third, there is a need for awareness raising. There is a need to increase the capacities of legislative branches, but also judicial and prosecutorial system on the specific harms that online system can bring to the gender equality. So I want to conclude my discussion, considering the fact that the minutes are very limited. As long as online crimes are understood and treated as loss, the benefits of the digital space entails will be completely outweighed by the damage done to human rights and fundamental freedoms. Particularly, I want to conclude my presentation by saying that we need to work in identifying the balance between the positive sides of online technology, but also at the same time protecting vulnerable groups of society like women and girls and children and all other groups as well. Thank you very much again, and I look forward to your comments.
Thank you very much, Professor Istrefi-Peci. Muchísimas gracias, profesora, por su excelente ponencia. Ahora, la intervención de la profesora Cristina Hermida de Llano, profesora catedrática de Filosofía del Derecho de la Universidad Rey Juan Carlos de Madrid. Now the floor is for Professor Cristina Hermida de Llano, is full professor of philosophy of law at the University Rey Juan Carlos of Madrid, Spain. Por favor, Cristina.
Buenos días a todos y a todas. Let me begin this presentation with muchas gracias en español, en particular al profesor Luca Mezzetti por haber cogido las riendas de este panel que iba a ser dirigido por nuestro querido amigo y el profesor Rainer Arnold. Es un gran privilegio formar parte de este equipo de amigos, por encima de todo, ¿verdad? Y estar aquí presente en una universidad muy querida para mí como española, en presencia además de sus familiares, Bárbara Arnold y su hija Antonia. Así que, bueno, pues para mí es un gran placer poder compartir estos minutos con todos ustedes. And my presentation is about freedom of expression of judges in social media. No one can doubt that judges and magistrates, as citizens, have this fundamental right. But what is also certain is that the question arises as to how judges and magistrates should express themselves in the public sphere, on social networks, in the media, or through the judicial association to which they belong. Here, I will focus on the right to freedom of expression in social networks, delving not only into the legal or disciplinary limitation, but also those required by judicial ethics itself, devoting some space to the recent case law of the European Court of Human Rights. Freedom of expression is not an absolute right. As regards the disciplinary liability of judges and magistrates in the area of freedom of expression, the Supreme Court in Spain has held that it should be interpreted restrictively. However, the Supreme Court has stressed that disciplinary order governing judges and magistrates has a broader profile than that of mere civil servants. It seems reasonable to think that this is due to the particular position that judges and magistrates occupy within the powers of the state as part of the machinery of the rule of law. If we analyze the recent case law of the European Court of Human Rights, we observe that it has repeatedly ruled on the right of judges to freedom of expression, considering their participation in political debate and criticism to be protected as a requirement of a true democratic system. For instance, Willy versus Liechtenstein, Kudeskina versus Russia, and Kosovo versus Romania. Indeed, in opinion number 3 of 2002, the Consultative Council of European Judges established the need to strike a balance between freedom of judicial expression and the requirement of neutrality, but made it clear that, as experts in the field, judges should also be able to participate in debates on policies relating to the judiciary, thus authorizing them to take a position in the public sphere. That said, it's also true that the Strasbourg Court has rightly emphasized the importance of judges exercising restraint in the exercise of their freedom of expression, so that, for example, they should not respond to possible provocation or use certain expressions invoking their status as judges, since to do so would call into question their impartiality and, above all, their appearance of impartiality, especially if they hold high judicial office. For instance, Kudeskina versus Russia. In reality, in my opinion, what lies behind all these warnings is that judges and magistrates should preserve the image of the judiciary, and in particular should safeguard the principle of impartiality and their own appearance, which has also been highlighted in the 2008 European Court of Human Rights resolution on judicial ethics, where it is stressed that judges should exercise their freedom of expression without forgetting the inherent dignity of the institution office they hold. Consistent with these considerations, the thesis will be maintained here that the position that judges and magistrates occupy in real and virtual life should have unity, given that they are not two different subjects, two different persons, because they express themselves on social networks or in real life, and therefore the scope of their freedom of expression does not vary merely because they are expressing themselves on social networks. If one recalls, one of the most emblematic cases on the freedom of expression of judges was Vaca versus Hungary. If this case seems relevant to me, it is because here the European Court of Human Rights referred to the three requirements that any restrictions of the right to freedom of expression should fulfill, namely, first, that it is justified, pursuing a legitimate aim. Second, that it is provided for by law. And third, that it is necessary in a democratic society. The European Court of Human Rights also underlines something of great interest, which is that the fear of a sanction could end up having a chilling effect on the exercise of freedom of expression, dissuading judges from making critical comments on public or political institutions for fear of possible reprisals or even loss of office. It was thus stressed that judges and magistrates, as members of the judiciary, should act as a counterbalance to the other powers, executive and legislative, which justifies their participation in public debate as long as it is in general interest. In my view, this aspect clearly holds true when a judge expresses himself or herself on social media. A case of great interest in this area is Cristina Rosaria Chavez Fernandez Figueiredo versus Switzerland of 24 September 2024. Here the question was whether a friendship through social media, especially Facebook, between the judge and one of the parties to the proceedings could constitute grounds for disqualification. The judgment states that the merest instance of a relationship on a social media was not sufficient to demonstrate a lack of impartiality. Moreover, the European Court of Human Rights emphasized that Facebook's concept of friendship was not comparable to the traditional sense of the word. Another very interesting case in recent case law is the Danilet versus Romania case of February 2024. And Danilet, the complainant, was a serving judge of a Romanian court, and he posted on his Facebook page a critique of abuses committed by the institution of powers in Romania. In analyzing the case, the Strasbourg court took the opportunity to explain that the internet constitutes one of the principal means of exercising freedom of expression insofar as it provides essential tools for engaging in activities and debates relating to political issues and debates of general interest, holding that websites contribute to improving public access to news and facilitating dissemination of information. In this context, the role of bloggers and popular users of social media could be linked to that of a public watchdog in terms of the protection afforded by Article 10 of the European Convention of Human Rights. Also of interest are the statements in this judgment made by the court on hyperlinks. In fact, good individual and institutional use of social media by the judiciary increases, in my opinion, public trust and the image of justice, according also to the report of the European Network on Judicial Council 2018-2019. Self-control in responding to criticism in real and virtual life is also required of the judges in their ethical behavior. Hence, point 32 of the Spanish Principles of Judicial Ethics specifies that the judge must show a tolerant and respectful attitude towards criticism of his and her or her decisions. In the same vein, for instance, the London Declaration or the Article 52 of the Ibero-American Code of Judicial Ethics. Thus, judges and magistrates must speak through their judgments. That is the point. So, by conclusion, it could be stated that although proper judicial participation in public debate is vital in a democratic society, it is obligatory for judges and magistrates to make use of the right to freedom of expression on social media, being aware not only of the legal or disciplinary limitation to which they are subject, but also of the ethical limits in the interests of preserving the principles of impartiality, independence, and integrity of the judiciary. The current challenge lies in finding, in my opinion, the right balance between the right of freedom to freedom of expression and the legal and ethical obligation, because both are indeed binding. Muchas gracias por su atención.
Muchas gracias, profesora Cristina Hermida de Llano, por su ponencia. Thank you very much for your intervention, Cristina. Now the floor is to Professor Valentina Colcelli from Italy. She is a member, investigator of the National Council for the Investigation of Italy. Ahora la intervención de Valentina Colcelli, investigadora del Consejo Nacional de Investigación de Italia. Valentina, por favor, 6 minutos máximo. Gracias.
Muchísimas gracias, profesor Mezzetti. Muchísimas gracias a los colegas que nos atendan hoy en este panel. I'm going to do the switch in English language, just to say in my 6 minutes, thanks to Professor Naldo, because I met him when I was very young, and I think about him as my teacher. In Italian academic word, we say maestro, in the field of European Union integration to the right. So I had a great depth with Professor Naldo, and I wish to say thank you, Rainer, wherever you are. And for the other 5 minutes that I had, I wish just to remember to European colleagues that are present, that I suppose they know very well about what I'm going to talk about, and wish to share with the colleague from the other rest of the world, that the European Union is the first place that has a regulation for artificial intelligence. And the aim of the regulation is to realize a trustworthy artificial intelligence system that are able to incorporate from the starting moment, from the moment in which the project of the realization is starting, what we call fundamental rights, of course, and rule of law. Is a very difficult task, as you can imagine. As Professor Mezzetti said, I work in an institution of physics applied. I'm the only jurist, so I'm a poor jurist, to be honest, that work close to the scientist able to develop artificial intelligence system. In our case, in the field of a medical device or software used as a medical device, applying artificial intelligence system. And so we try to incorporate the value of fundamental rights and the principle of the fundamental rights by design at the starting moment is a very difficult task. Because we have, first of all, to take into consideration that this Artificial Intelligence Act, this regulation that as the European Union based the approach on the artificial intelligence to the risk. What type of the risk on the fundamental rights of the user of this system could be affected, could be realized applying one of this system. To try to avoid this possible risk that could be gender discrimination, ethical discrimination, or social and economic discrimination, etc., of course, the European Union try to give, or give us, okay, more political correct, give us some instrument to do this type of evaluation. That is the fundamental rights impact assessment. For each artificial intelligence system that will be put in the market, because the point is to put in the market the artificial intelligence system. Each developers, each deployers, each producer have to realize a fundamental rights impact assessment to evaluate with a very large list for the evaluation how the fundamental rights of the potential user could be affected. This only for the system qualified as a high-risk system, but all the type of medical device or clinical trials that can use or involve the using in the activity of involving artificial intelligence could be defined as high-risk system. So all type of this type of activity have to be put in the market just if there is a fundamental rights impact assessment that is an evaluation about what type of a fundamental right of the user could be affected by the using of this system, and also evaluation how to mitigate these potential damages or risk. I'm going just to I don't know if I'm in time in this my 6 minutes, but I wish just to underline that this type of activity that is requested for all type of system that will put in the market is not a request for the research activity. The research activity in the European Union legal dimension under the European Regulation of Artificial Intelligence Act is not under the application of Artificial Intelligence Act, our regulation on this topic, because the point is that the evaluation on the risk have to be realized for the system, for the systems of artificial intelligence really employed by user and the market. That means two things very important. That means that the research activity has a fundamental right, because also the research activities is a fundamental right. So the guarantee of the freedom of the research is a fundamental right. Could realize also research in the field of high risk that is avoided to put in the market according to the Artificial Intelligence Act. The research activity could be also realized in the prohibited artificial intelligence system. But I'm going to say goodbye to the audience, and also, but we have to remember that also if the research activities is out of application of the Artificial Intelligence Act, in any case, the principle of respect of fundamental rights have to be, in any case, to be applied, also if the researchers have not to use the fundamental rights impact assessment. Thank you very much.
Thank you very much to Valentina Colcelli for her intervention. I'm sure I'm appearing to you as a new Leviathan in regulating times of exposition, but it's not due to me. At 10:30 is starting is going to start a new panel in this same room, so I'm really sorry. Now the floor is to Alan Bronfman from Chile, professor of constitutional law and parliamentary law en the Pontificia Universidad Católica de Valparaíso. Ahora tenemos la intervención de Alan Bronfman de Chile, profesor de Derecho Constitucional y Derecho Parlamentario en la Pontificia Universidad Católica de Valparaíso. Por favor, profesor.
Muchas gracias. Muchas gracias, profesor Mezzetti. ¿Se escucha? Sí. ¿Ahí se escucha? Sí, perfecto. Muchas gracias, profesor Mezzetti. Para mí es un honor participar en este... Sí. Cortísimo. Voy a hacer una exposición Twitter, ¿no? X sería el lenguaje contemporáneo, muy, muy breve. Agradezco, por supuesto, esta invitación. Es un profundo honor poder participar en este homenaje al profesor Arnold, ¿no? Querido amigo para todos nosotros, y claramente su espíritu está presente en este encuentro, ¿no? Y en ese sentido, como digo, es realmente una profunda satisfacción poder participar en este encuentro. Seré muy breve. Quiero referirme al creciente carácter periférico de la Constitución en la regulación de las democracias contemporáneas. La Constitución cada vez de manera más evidente va quedando fuera de la regulación de los principales procesos políticos. No voy a referirme largamente a la democracia digital, varias de las presentaciones anteriores la han mencionado. La democracia digital está presente en el régimen constitucional de manera significativa. Hay elecciones que han sido intervenidas mediante medios digitales, claramente. Hay elecciones que han sido anuladas como consecuencia de acción digital, ¿no? De acción en el mundo digital. Luego, es indiscutible que estamos ante un fenómeno que se va a extender dentro de todas las democracias en mayor o menor medida, sin perjuicio de la existencia de instituciones democráticas reguladas en la Constitución. En la historia de la Constitución, seré también muy breve, en la historia de la Constitución, en su origen, ¿no? El ejercicio del poder político se encuentra regulado fundamentalmente a través de la separación de poderes y a través de las limitaciones establecidas por derechos fundamentales. Esa regulación original, estoy pensando en la regulación constitucional del siglo XIX, es una regulación constitucional que se adapta a la realidad de esa época. Las constituciones no se ajustan de manera muy rápida al surgimiento de un nuevo tipo de organización, que son los partidos políticos. Los partidos políticos comienzan a tener una fuerza importante a fines del siglo XIX, comienzo del siglo XX, partidos de masa, partidos democráticos. Kirchheimer habla de los catch-all parties, ¿no? Con partidos, atrápalo todo en su traducción en español. Las constituciones se adaptan lentamente, de todas maneras en el presente una buena parte de las constituciones de la segunda mitad del siglo XX tienen disposiciones específicas respecto de los partidos políticos, ¿no? De los partidos políticos, sobre financiamiento, algunas prohibiciones, normas acerca de transparencia, eso es todo, ¿no? En las constituciones. Pues bien, y aquí ya voy terminando, ¿no? El régimen constitucional nos dice muy poquito acerca de lo que está pasando en esta democracia constitucional, muy poquito, muy poquito. Este mundo digital no está siendo cubierto satisfactoriamente por la regulación constitucional. Aquellas constituciones que lo hacen regulan los partidos políticos. Los partidos políticos son uno de los protagonistas de la democracia contemporánea. Otros protagonistas, los estados extranjeros, con frecuentes intervenciones en otros países. Las plataformas digitales que realizan cuestiones que pasan desapercibidas o no son objeto de debate constitucional, como la censura. Las plataformas digitales se censuran, sin ningún problema, ¿no? Tenemos robots, ¿no? Robots que intervienen, personificaciones a través de inteligencia artificial. En fin, el protagonismo de los partidos políticos es relativo y los partidos políticos, por supuesto, están interactuando con agentes que no forman parte de partidos políticos y que están realizando campañas permanentes en el mundo digital. Primero, conclusiones. En lo orgánico, el foco puesto en la Constitución en los partidos políticos, la verdad es que requiere ser repensado. Segundo, en el ámbito de los derechos fundamentales, la existencia de la libertad de expresión diseñada y concebida de acuerdo a los parámetros del siglo XIX es una libertad de expresión que en el fondo está amparando todo un conjunto de malas prácticas dentro del funcionamiento del sistema democrático. Como se ha dicho repetidamente en el derecho constitucional contemporáneo, la utilización de la libertad de expresión como arma política, como arma para destruir al enemigo, para construir imágenes políticas, ¿no? O destruir imágenes políticas. Pues bien, nada de esto es abordado por la Constitución. La justicia constitucional tiene muchos problemas cuando se intenta enfrentar con esta nueva forma de democracia, ¿no? En la cual tenemos, se mencionaba hace un momento, ¿no? Manipulación, influencers, medios digitales, sin control, que no son medios de comunicación, las plataformas se definen como neutras, ¿no? Y en ese contexto, la Constitución pasa a ser irrelevante. ¿Cuál es la cuestión que me gustaría subrayar? Y con esto termino. Lo que me gustaría subrayar es que debemos discutir constitucionalmente la democracia en el mundo digital. No desde el punto de vista de las tecnologías. Las tecnologías tienen su normativa, hay una regulación europea sobre datos, ¿no? Hay varias regulaciones, ¿no? Sobre esta materia, pero la cuestión tiene que ser debatido desde la perspectiva del derecho constitucional y desde la democracia, porque de otro modo estas herramientas que tenemos en la Constitución pensadas en el siglo XIX, ¿no? Son herramientas que son claramente insuficientes y que no se adaptan a las nuevas realidades políticas democráticas. Muchas gracias.
Muchísimas gracias, profesor Bronfman, también para respetar el tiempo. Muchísimas gracias. Thank you very much. Now the floor is to Ruth Bogatyrow of Kraft, United States of America, member of Falcon, Rappaport and Bronfman. Ahora la intervención de Ruth Bogatyrow of Kraft, Estados Unidos de América, socio de Falcon, Rappaport and Bronfman. Please.
Thank you, sir. Okay, can you hear me? Is it working? Okay. So, first of all, it's a great privilege and an honor to be on this panel with such distinguished jurists and academics. And I have stood in both of your sets of shoes before deciding to end my career in private practice. I think it's no secret coming from the United States that this is a particularly fraught time for us with respect to the rule of law. I could have never believed that we would be at this point in terms of governments questioning the rule of law, the application of law by our courts, and when you spoke about social media, the fact that social media is being used to dox judges at the highest levels of our government, and that is terrifying. And I'm sure Justice Sotomayor will have something to say about that tomorrow. She's more outspoken even than I am, and she was a year behind me in law school, so I think I know her pretty well. Let me say this about AI. What is the goal of AI? It seems to me that in legal process, sometimes the courts are the stepchildren of governments. And that is the case in the state courts in which I served in the United States. So the question is, do we use AI, or is there an imperative to use AI because the judicial process is so slow and judges are fallible? And in my system, in the state of New York, many judges are elected. So they don't rise to the bench because of their academic credentials or their intellectual acumen. So there's a big push to use AI, and I was part of a committee in New York that began the use of AI in our court system. And the truth is that for most individuals, their access to justice comes at the very low-level tribunals, right? And so those have tremendous volume, and there's more pressure to use AI. But AI should not be used to overcome the shortcomings of the legal system and without addressing the moral and social consequences here. So I think we all have to say to ourselves, are we tech positivists or are we tech negativists? And if we are in one of those two categories, is that enough of an analysis, or do we need to go far behind this? So in the closing days of the Biden administration, President Biden set up a task force inside the United States Department of Justice to address AI. Why? Because there were serious concerns about the safety, the security, and the trustworthiness of artificial intelligence. And Professor, you spoke about the hallucinations, right? The AI creating false narratives, malicious use of AI by criminal and other actors. And how does that affect democracy and the functioning of the rule of law? And so technology, I think, has the ability to amplify the good and amplify the bad at the same time. And certainly that is a problem. So in our courts, you may have heard that there's been some controversy regarding artificial intelligence by attorneys appearing in the courts of record. And I noticed that that has happened elsewhere. There is an excellent article about the adaptation of AI that indicated that in Colombia and in Mexico and in Peru, judges have used ChatGPT to write their decisions. Okay? So, but in the United States, we really had a big controversy. In New York, there was a case in our federal court system, in what we call our mother court, the Southern District of New York, in which an attorney in private practice, a solo attorney, so he had limited resources, I suppose, argued using cases that did not exist. Just made them up. ChatGPT created cases from its algorithm. And the judge, I have to tell you, in our federal courts, they're very sophisticated. And the judge researched and said, this case doesn't exist, counselor, and sanctioned the attorney. That's called Rule 11, where you can sanction somebody for bringing a frivolous case or arguing falsely before the court. And you may know that recently in the federal court in Washington, D.C., that the Justice Department is now being frankly reamed out by Judge Boasberg for making arguments that lack basis in law as well. But the use of AI and ChatGPT are incredible. There's actually a judge in the Northern District of Texas who, I kid you not, implemented his own AI rules. This is the first in the country. He says AI has to be certified. The attorney must certify the validity, and there will be a human accuracy check of cases that are cited. And God forbid you cite something that is not a real case. You have to testify that no portion of a filing will be drafted by generative AI, such as ChatGPT, Harvey, or Google Bard, or any language drafted by generative artificial intelligence will be checked using the print reporters and legal databases, i.e. real law books, real cases, by a human being. And if you do not say that, you're in big trouble. You can be sanctioned by the court. And the judge notes in his preamble that the use of hallucinations, making stuff up, even citations, even quotations from judges who don't exist, is highly problematic. So attorneys, we swear an oath, and on May 1st, many of us retook our oath and commitment to the rule of law. May 1st was Law Day in the United States, and it was the most memorable law day, and I've been a lawyer for 46 plus years. The AI does not swear allegiance to the Constitution, to the rule of law, to a client. And that is highly problematic. So if you are not bound by duty, by honor, by conviction, based on a computer program, this can be truly problematic. And what this judge in Texas has ruled is that if you do this, your pleading will be struck from the record. Undoubtedly, that lawyer will be sued for malpractice by his client at a later point in time. The EU, as you noted, is in the forefront of evaluating the critical issues in AI. And that is truly significant because the issues include algorithmic transparency, fairness, liability, and accountability. So these are really ethical and moral questions at their core. Can AI have an implicit bias in what it generates? Who is liable? Who is accountable for what is promulgated through the AI and represented? And you know, it's really funny because I've actually gone on AI recently to check a particular issue of law and discovered that what was on AI, which was proffered in an employee handbook, I specialize in management side employment law, there was reference to pregnancy discrimination laws and pregnancy combined with disability, which we kind of call the Bermuda Triangle when you have these intersecting laws. And it referred to rules of law that do not exist, literally do not exist. And I finally said to this client, where is this coming from? And she said, I didn't want to pay a lawyer, so I went on generative AI and generated an employee manual. And so it was completely made up. And the issues did not intersect at all. So that was highly, highly problematic. And so I think that the critical thing in the development of AI,
you have to conclude, please.
am I done?
Please, please.
Is investing all of the stakeholders in the development, which is exactly what you were saying, right? Two of you. Okay. All right.
Thank you very much for your intervention. Last intervention is by Ricardo Rios Ferrer from Mexico. Is president of the General Council of the Mexican Bar of Advocates, presidente del Consejo General de la Barra Mexicana de Abogados y patrono de la World Law Foundation. Por favor. 5 minutos. Sí, lo sé, pero me perdona, su insistencia no es compatible con el hecho que comenzamos con 15 minutos de retraso. Y estos 15 minutos de retraso no se deben a nosotros, sino se deben a una organización que nos dejó entrar con muy lenta a la entrada. Entonces, lo siento, yo no puedo perjudicar gente que ha viajado horas y horas hasta acá, ¿me entiende? Ok, gracias. Por favor.
Muchas gracias. Thank you very much. Thank you for your attention. I will not read a preparation or anything because I probably have a couple of minutes. I just want to convey the message, the primary message that I wanted to communicate to you through that paper. Basically, the message is that as of today, the concept of rule of law is not well known by the masses. And technology should be an instrument to generalize that knowledge, because the use of technology, what has favored in many influential countries as of today, is the rise of populism. And populism has been twisting the concept of rule of law and falsely attributing to it a different concept than it truly is, for its own purpose, for its own sake. We all know that through technology, internet, and artificial intelligence, etc., information is disseminated and communication is established through social networks. Those are instruments that populists are using and exploiting to their own benefit. So the basic message that I wanted to convey again is that we should all strive to protect the real concept of rule of law, use technology as a means to generalize that concept to the masses, and possibly even try to create from technology and social media a fifth power that could be a counterbalance to public powers. That's it. Thank you.
Así, al final terminamos con 1 minuto de antelación. We finish 1 minute in advance. Thank you very much to all panelists for your participation. Thank you very much to you for participating. Muchísimas gracias a los panelistas por su participación. Muchísimas gracias al público. Nuevamente, si me permiten, muchísimas gracias en particular a la señora Bárbara Arnold y a la hija de Rainer, Antonia Arnold, por su participación, que nos ha profundamente honrado. Y le dedicamos los resultados muy positivos de este encuentro que Rainer había organizado, no yo, él. Se lo dedicamos a él para que disfrute de donde se encuentra. Muchas gracias.